Hello, hello, hello. I'm Kirsten Hildebrand of Hildebrand Law Firm, and I'm so grateful that you are here today. We are going to discuss a really important topic that has to do with you, and that is the titling of documents and what that means in terms of ownership. Now, this can be really confusing. It's actually something that even appears on law school exams, and so there can be some nuances and some ways in which things can sort of go sideways if you don't truly understand what it is that you're doing when you go to the bank or when you're sitting down at the closing, and what you're actually looking for when you look at documents involving you and or someone else. So we're going to talk today about when and means and when and doesn't necessarily mean and when or means or. So this is going to be great. The first example that I want to give to you is when you have a married couple. And this I start with because it is actually the most simple of all of the different scenarios regarding ownership. And in this scenario, when two people are married, you can have the titling be Mary Smith and John Smith. And what that means, by virtue of the use of the term and, is that both of these married individuals own that asset 100%. And it's also called joint ownership. So joint ownership means if Mary Smith were to pass away, then John Smith would automatically get 100% of the asset in his name. Now, what you have to do is make sure to terminate the right of the deceased individual through something we call an HT 110. So it's still a great idea to come to us and help you get through that process, but ultimately the legal conclusion is that you own that property 100% as the widowed spouse of the individual. Now, if it is a scenario, though, where people are unmarried, let's say it's a brother and a sister, or let's say it's a business partner and another business partner that own a piece of property together. If that is the case, then the term and, so if it's now owned by Kirsten Hildebrand and Matt Kaplan, two separate individuals, and it has the and in the middle, does that mean that each of us own it 100% in a joint ownership capacity? And the answer is no, it does not mean that. By virtue of the statute, if it says Kirsten Hildebrand and Matt Kaplan, it's actually considered to be tenants in common, meaning I own 50% and Matt Kaplan owns 50%. And if I were to pass away, my 50% interest does not automatically go to Matt. My 50% interest needs to go to my heirs. In this case, it would be my husband. And he would slip in and he would own 50% of the asset with Matt Kaplan. So if you wanted to have two unmarried individuals actually have joint ownership of something, you have to say so. So it would need to be Kirsten Hildebrand and Matt Kaplan as joint owners with rights of survivorship. If it does not use that magical phrase, then there is no survivorship interest that Kirsten Hildebrand has for Matt or that Matt Kaplan has for Kirsten. So that is a really interesting twist on the whole thing. So now, is it possible then for Matt Kaplan or Kirsten Hildebrand to own? If it has or in the middle of it, then that also means tenants in common. It does not mean joint tenancy. So that would be the short form of what I just gave to you. A little more confusing, so we prefer to use the more extensive definition so that then it is possible for people to really understand by looking at the document what is absolutely intended, and that is that there's a joint tenancy 50%, and not that there's tenants in common, which is 50%, not a joint tenancy. So in order to make unmarried people have a joint tenancy, is that possible? The answer is yes, but you would have to say so. And so you would have to say Kirsten Hildebrand and Matt Kaplan as joint tenants. And if you use that phrase, as joint tenants, then in fact, that would allow for the 100% beneficial interest to then come into play. So what about the situation where unmarried people may want to not have something be presumed as marital property with joint tenancy and rights of survivorship? Well, then you would have to say so. You would have to say Kirsten Hildebrand and Lee Hildebrand as tenants in common. And then that would mean that my 50% interest can go to whomever I designate, and my husband's portion can go to whomever he is designating. So it is possible to do that as well. Now, here at Hildebrand Law Firm, we want to make sure that all of that is clarified in a marital property agreement. Marital property agreements are and will continue to be really important in the future because of the changes that are coming with respect to the federal estate tax exemption. But with respect to this, a marital property agreement can then back up the document, the deed, and say, okay, what we really intend with this property is for Kirsten Hildebrand to own 50% of it as her individual property, and she intends to name separate individuals. Then Lee Hildebrand, who owns the other 50% of this property, and then maybe has it going to other individuals. But a marital property agreement is really important because then that solidifies what our intentions were and gives an opportunity to expound upon what that beneficial interest looks like and who it is going to go to. So that's just a little bit of a primer on the issue of how to title things and how complicated it can get. And so it is our recommendation that you always come to Hildebrand Law Firm and talk about these titling issues, and also make sure that they fit within your overall estate plan in a way that makes sense, and make sure that everything can transfer or pass in a way that is the most smooth possible. Thanks so much for joining me. I appreciate you listening, and I look forward to seeing you again.